It's 10 years since Lord Woolf introduced the current civil procedure rules. From the 1st of October this year, there are important changes that every expert needs to be aware of. For example, all legal reports now need to include a statement of awareness of Part 35. With me today to tell us about the crucial changes is Isabel West, who heads up the Expert Witness Group at Bond Solon. Isabel, what are the main changes?
Mark, there are four main changes: the definition of an expert, guidance on the use of single joint experts, a revised statement of truth, and a new, what one might call, declaration of awareness, and lastly, clarification on the written questions that you can put to an expert witness.
Well, let's look at each. Firstly, the definition of an expert.
Yes, the civil definition has been harmonised with the definition of a criminal expert that appears in the criminal procedure rules.
Secondly, single joint experts.
Yes, some guidance has been provided on the use of single joint experts. So if you have a small track claim or a fast track claim, then the rules now say that normally, if you are permitted to instruct an expert, normally you will only be allowed to instruct a single joint expert.
And what about this statement of truth and declaration of awareness?
The statement of truth has been revised, and experts must now make a very clear distinction between facts that are within their own knowledge and facts that are not. And the facts that are within their own knowledge, they must confirm to be true. The new, what I've been calling a declaration of awareness, requires the expert to include in his report a statement to the effect that he is aware of the rules, the practice directions, and the protocols.
And finally, written questions.
Yes, some clarification has been given on written questions to experts. So the written questions must be proportionate. For example, no cross-examination and no attacks on the integrity of the witness.
So no cross-examination by post?
No.
The importance of keeping up to date with all the new rules is stressed by leading QC Ali Malik.
It's quite plain that the expert now has to be on top of the rules, and there's a statement that has to be made in the report that he's fully aware of his obligations and that he's complying with them.
Guy Henderson is a senior member of the Commercial Litigation Group at Allen & Overy. He has been involved in the instruction of numerous expert witnesses. So Guy, what are solicitors looking for, particularly bearing in mind the recent changes to the rules?
Mark, the new changes to Part 35 really emphasise the primary duties of an expert, which are to assist the court, not to be a hired gun or an advocate, and to give unbiased evidence of opinion on matters within their expertise, based on all the facts, the helpful and the unhelpful. It's therefore vital that experts really do understand the detail of the rules and regulations that apply to them, something which is emphasised by the changes which now require them to make a positive affirmative statement that they do so in their evidence. And this means that instructing solicitors will be anxious to satisfy themselves that the experts they propose to put forward really do understand the rules. And it's therefore vital that the experts who are consulted by solicitors who may instruct them are able clearly to demonstrate that to the solicitors.
So what should experts do now?
We will be outlining these changes at the annual Bond Solon Expert Witness Conference on the 6th of November. We have Lord Justice Levison, the senior presiding judge, as our keynote speaker this year, and he will be giving us the perspective of the judiciary. Also, we're running some new half-day courses after the conference so that experts can come along and get themselves completely up to date on the rules, the practice directions and the protocol, and this will allow them to sign that declaration of awareness with absolute confidence.
Experts need to act now to ensure that they are fully up to date with all the legal requirements of their work. Ignorance of the law is no excuse. Do visit bondsolon.com.